before that. Before the Honorable Court start this matter, it is likely to take some time. Serial number 70, which is mentioned in the morning for priority. So, it is not likely to be taken approximately.
What is
the matter where Lordship has issued the notes in suit 711. Suit was rejected because of
you can take the date. You can take the date from the court. You can take the date from court master.
Please, this is for final hearing. This is for final hearing of the first appeal.
Yes.
May I just briefly point out the background of. As the appellant herein is challenging the order of grant of divorce in favor of the husband, the marriage had solemnized on 20th/11/2010. Since 2011, that is 24th of October 2011, the wife had to move out from the house for certain reasons. Thereafter, an admitted position again comes on record that the husband comes into a relation with a female. Within a year of that relation, they have twin children. Ultimately, I filed FIR under 498. I filed domestic violence. I filed 125, and the husband has moved this divorce petition. This divorce petition came to be heard, and I'll take your lordships to each and every finding. It is absolutely a one-sided order, wherein whatever the husband has stated is believed as a gospel truth without asking for evidence. And whenever a wife has stated something, the court has clearly observed that there is no material evidence which has been placed on record. Now, the two grounds which are considered by the lower courts while granting divorce is desertion and cruelty. Now, for cruelty, there is a clear finding by the learned family court that filing false complaints against the husband amounts to cruelty, wherein there is no acquittal or no finding of any court whether these complaints are false. The FIR which was filed is pending before this honorable court as quashing petition was filed, stay is granted, but final adjudication is yet pending. Therefore, none of the courts have opined that any complaint filed by the appellant is either frivolous or false. Another part is desertion. I put up the case before a lordship that my case is that the husband was having illicit relations. Ultimately, it figured out that one lady was in a relationship with the husband. They have now two children with born out of that relation. They are staying in living relation since admitted position is 2013. My case is he was in relation prior thereto. But ultimately, after recording every such admitted position of facts, the court comes to a finding that the appellant herein has committed cruelty. Nonetheless, in a situation where a wife is put, where the husband, the allegation put by the wife in the cross-examination as well, the examination as well as the evidence, is that the husband was treating her in ill manner. He was getting drunk and trying to beat her. He was having relations. That is how she had to move out. She is suffering from all these years in which, according to the husband, is cruelty committed by me. He is enjoying his life with a female and children, and he is continuing his family life. Now, ignoring all this aspect, the learned family court, I will take your lordships to the finding. If in the paper book, I will kindly have page 251. I will take your lordships to necessary.
Whatever might have happened along the line, there's no possibility of them to just resolve it out.
In fact, before this honorable court, an attempt was made, but that has failed. Because the case of the wife is that she has suffered a lot, and for that she is not unable to give up. That is the issue.
Are they going to reunite?
No, that is not a
problem. Then,
even when
if they are not going to reunite, and if there is no possibility, and if suppose this court says that, and if we hold that the decree of the trial court is absolutely wrong, and then what? Are they going to reunite and they want to continue?
That seems, I understand what is falling from a lordships, but
see, if he is in a relationship, if he is also having the children out of that relationship, Be sure that wife is not going to go back to. They have any children born out of this?
I'm sorry.
They do not have any child born
No,
out
they do
of
not have
this.
any. Out of the bedroom,
Alright.
there is no child.
Why can't she move on?
But that is what she is finding.
We will try to see that no damage is done, and if need be so, if parties they arrive at a compromise without entering into the marriage, we can definitely say that this is the observations or the findings of the courts. We will set it, not.
But that attempt, in fact, was made before this honorable court. I candidly inform you also that the same attempt was made.
Mr. Thakur, when what is now left in 2010, today it's almost 12 years.
But ultimately, the point of the wife is, before filing this very question had come up in my mind also. Very frankly, what the wife has said is that she has suffered from 10 years. She is continuing to suffer. Ultimately, she is not being able to move on or come out of what she has gone through all these years. On the other hand, the husband is enjoying his, as such, it is called a marital life. Though they are saying that it is they are staying in a live-in relationship. He is enjoying his life. He has children. He is moving on as such since 2013, admittedly.
Now, suppose that's what you're saying. We are allowing your petition.
Please no.
Right now without hearing Mr. Raju, without going into any kind of this thing.
But that will not lead to anywhere. That is, I also understand that aspect.
We can understand that there is nobody in his life. We can understand that you want to go back. There's a possibility of this.
I follow.
See, that doors are completely closed. There's nothing. See, if you don't have a house, we can direct him to give you a house. You can be on your own. Even if you're with your parents, you would be entitled to your house. We're sure that Mr. Raju will not be arguing on that aspect. He knows the judgments of the Supreme Court right from the beginning, which says that the maintenance doesn't mean just the living, food and clothing and all that. It's a respectable living also is a part of, so that is something which the court can take care of it. But then now to just say that, no, I cannot forget it, I cannot forgive him. Understandable. You've been hurt. You do not want to do that. But then
where it has to end. I follow what is falling from.
And we'll send you to the best of the marriage psychologist, both of you. If he thinks that he doesn't require it, fine, good luck to him. If you feel that there is a Buddha Counseling Center of Forensic Science Laboratory, she doesn't need to travel, she doesn't need to go anywhere. She can take those things and she can unwind herself. The past many times is a baggage for many of the people. So let her take that and move on.
Thanks.
Is she an educated lady?
She is educated.
Is she doing anything? She's a professional.
As of now, she is doing some work contract basis with the government. She has done M.Pharm and B.Pharm.
Tell her to just move on and why to. Nobody is, worth spending your entire life brooding over the events which had happened. I don't think that we should give anybody so much of an importance. And particularly the person whom you don't respect, whom you think is not somebody who has respected your feelings. Why do you want to spend your time, for all this? And again, this is going to further.
It will aggravate this.
Mr. Raju, has anything to say on to the amount of permanent alimony or anything?
No, in fact, that was, I don't want to say beyond what is followed from the Honorable Court. That is precisely what my client is saying. It's like, we just have a look at 2-3 aspects.
Please switch on your mic.
Your leadership, I'll not take further the merits, just 2-3 aspects. This is a marriage span of less than 1 year, 11 months old. 2011, admittedly, she leaves the house. In 2013, I entered a relationship because 2012, what is not said is there is a customary divorce. There are documents signed by family members as per the custom where all the entire Dagina access returned to her. That happens. No communication for her for 4 years. In 14, once I have children from the live-in and she comes to know of the same. In 15, she files the first FIR of bigamy against me and 498A. And then in 15, after 4 years of desertion, for the first time in 15, she files these proceedings in the cross-examination. In the record, she is asked that today do you want to go back to him? She says yes. She is asked in the last 10 years, have you ever spoken to him once? No. Have you moved a restitution application even once? No. Then today, why do you say? Because today for the first time, someone is asking me if I want to go back, so I'm saying yes. She is asked about my parents' birth date, she doesn't know. My mobile number, there are so many, for the last 10 years, she's asked, have you spoken once to him? She says no. The entire, so therefore the entire, in the entire suit.
Fine.
Just one last.
What is the agreement? What is the agreement that you said? It's a customary divorce.
It's a 2012 agreement which we have produced before the Honorable High Court in the
It's a customary divorce.
It is not there. When she is asked about the agreement, she says, I don't know signatures of my uncle, I can't remember. Therefore, that is not taken on record in that sense. But we have produced it.
No, her signature is there.
No, her uncle. This is because it's a Samaj, this thing, her real mama and all, they have signed
So
it.
what? I mean, she's herself. How can mama decide for her?
No, I'm saying because it is the customary as for taking back the Dagina, etc. But that has not been believed. That is not the ground on which it is granted. My only submission is today in the entire suit to let me appreciate a person who is trying to portray a married life and only document produced on record of 7 baar utara. In the end, she is not produced a single photograph, something to show that there was some entire, your ladies may look at the entire evidence produced by her. Only evidence produced by her is he owns this land, he owns that land. Therefore, in a divorce proceeding, when a wife is contesting, stating that I want to resume matrimonial relationships, the only documents she produces on record are he owns this land, he owns that land, except for land documents. Not a single document produced on record.
Well, that if my learned friend wants to address, and I must show what he has produced and what the court is observed to believe.
But in a divorce proceeding, a wife who was left for 10 years, she would produce something to show there was some matrimonial. She had left in 2011. And she admits that she has not spoken to her 10 years. Of my father was hospitalized, she said, I do not go, I have not met him. When my father had serious injuries, so there is no relation for the last 10 years.
Why is it an agreement? You knew that the agreement ultimately, either by way of a customary divorce that you need to separate, or by way of a decree before the court of law that you need to separate.
Please
you can't have an agreement and say that I've given away this or that. And
no, therefore I have moved this divorce application.
Precisely.
Because I realized that she is not willing to honor, therefore I moved the divorce before the consent.
So don't rely on the document.
No, I'm not. I'm only pointing out that this is the rationale. In fact, I moved the application on these grounds. And the Honorable, and today also, in fact, even before the Honorable Coordinate Bench, they were called in the chambers. And my client, because ultimately what has happened, there are various amounts which have been paid in other proceedings also. In these proceedings also, the total amount was some 45 lakhs. It was deposited, and under the order of the Honorable Court, without prejudice to her rights and continuance, she was allowed to withdraw the same, and she has withdrawn the same. And therefore, even the Honorable Coordinate Bench had called in chambers. Again, I am not going into the contents of the discussions, but ultimately the parties decided that it was not agreeable to come to a mutually acceptable figure. And that is where it got stuck. Otherwise, as far as the merits were concerned, we had pointed out that this is the situation. Honorable Court did not enter into that, but the parties were called. So they were called.
In any case, marriage, look, I mean, we're not saying that the marriage what can be, the agreement can't be looked into, that is out of question. If the lady has signed it and she backs out and she says, I don't remember it, there is something which the court can definitely look into. But here to say that we entered with mama or somebody, who on her behalf has said that no, she's going to now sever the ties, that's unpalatable. But so far as your state or your, conduct so far is also, why is that in his petition, Mr. Raju is right. Why no restitution of conjugal rights in all these years?
But there I agree, but there my lord may kindly appreciate the mental status of a person also, that once she has been left high and dry, thereafter it comes to the knowledge that he is already living with somebody, but with what face she would ask to go back?
She has said so she wants to go back in the process in her examination. I'm sorry.
So far, till the period, my lords may kindly appreciate. Section 9, I understand.
Anyway, you can argue this out if you want to do that, but if we according to us, this is not a matter worth arguing. And so the present status of both of you is such, you never asked for restitution. He went in 2014, asked for this, and therefore you went and say that I want now the divorce. I want to go back and then have to start my marital life. This is something, which is showing that you're not serious.
Come on record, I am a first year BCom failure, she is a PS, so therefore she has admitted that they were serious. If she is a highly educated person, I am a FY BCom person who not even cleared my second year. She admits that there were serious mental issues.
I request,
there are all this coming on record.
I request one thing. After my lord may kindly read only the findings of the court. Whatever my learned friend is saying will just fall down. Because what the learned family court has believed is what my learned friend is saying has come on record. He has completely ignored the position of law and observed anything. It is an absurd order in my opinion.
We, from the very beginning, without even hearing either of you, we had said that in its present form, we will not allow for the matter to continue. If the reasonings, ultimate conclusion is something, which we find that now if there is a possibility of something else to happen, we can say that, all right, this is not acceptable. But if the reasonings are hurting you or it is the impediment, we'll see as to in what way we can work it out.
And I have no objection that I cannot have. In fact, that is beyond.
And so far as the permanent alimony is concerned, according to Mr. Raju, around 45 lakhs you have that has been given. Anything else that you want to say for that? And what is his capacity?
On that, perhaps he has immense capacity. That is what was taken into chambers and considered. What my client wants is, it was pointed out.
If she wants, Mr. Raju, you can also inquire from your client also, and you can just ascertain from your client. She would be entitled to have her own separate residence. Mr. Raj, you can ask your client as to whether the separate residence, she would require, because even if she's residing with her parents, she would be entitled to that. So we'll just say whatever the amount that has been given, I do not know what is your capacity and how much you have been able to give, but then there's a respectable residence that let her have it.
I will take some. The only difficult what has happened, I appreciate that I can understand a person having a marriage span, 11 months marriage span, 10 years in the aspect of
Don't argue that
factor as far as this. So I take some. I'm not denying that. In fact, the amount also I point out
that. If you're married even for half a day, once there's a legal tie, that is something where we are trying to work it out.
No, I'm not joining an issue in that. I take sense. I will take.
This is not.
Please. In fact, my instructions were that they have paid total of 58 lakhs, 13 lakhs in insurance and 45 lakhs as part of this lump sum payment by the family court. But in addition to that, the residence part I will inquire and
you will also need to bear in mind that 58 lakhs is the amount which has been already given to you. So where are you residing? Which place?
Jamnagar.
Jamnagar. With your parents.
Sorry, the remaining amount which my friend is referring is for the maintenance which was ordered by the court over the period of time.
Correct, but then obviously everything, total will have to be discussed. You can have to be considered.
11 years have passed.
No, that is true. But then at the same time, it's ultimately one he will calculate because he has paid from his pocket, so he will calculate.
No, I understand. Okay.
So doesn't matter. But then now both of you just take the sense as to how and in what way. We are of the opinion that there is no possibility of further any other order other than what has been passed by the court.